Hello, everybody.
Let's go on the record in the matter of People's State of Michigan versus Akey, file 251946FY. My understanding, this is going to be a plea and sentence, so can someone explain to me what we are going to do then?
Yes,
Let's have
Your Honor, good
appearances
afternoon.
first.
This is Adam Townsend and Abigail Cote on behalf of Mr. Akey, who's seated here to my right. Your Honor, we reached an plea agreement with the prosecutor's office in which Mr. Akey will plead to an assault and part of the domestic violence, which is count 2 of the felony complaint. We understand and have an agreement that that will involve diversion and deferral of the conviction with no upfront jail time, and also a dismissal of the felony child abuse count, which is count 1 of the felony complaint. That's the defense's understanding, Your Honor.
Mr. Duffield, so it's going to be a plea to count 2, dismissing count 1?
That is correct, with the hope that the defendant would be accepted into the domestic violence diversion program.
Mr. Duffield, do you have victim notice?
Apologies, Your Honor. Yes, I believe we do.
Well, the reason I ask is because they have a right to be here for sentencing if they choose to be. So we can proceed and take the plea and set it for sentencing, or we can proceed to sentencing if indeed there's already been victim notice and they have.
Yes, Your Honor. According to my notes, I'm sorry, we have contacted the victim and I don't believe we've heard a response, so we are sufficient to proceed to sentencing as well as taking the plea today.
All right. Mr. Akey, you heard what your attorney stated and what the prosecuting attorney has confirmed?
Yes, Your Honor.
You understand, sir, that you have a right to proceed to trial, and if you did proceed to trial, the prosecution would be obligated to prove that you're guilty of the charges brought against you beyond a reasonable doubt. You understand that?
I do, Your Honor.
You understand further that if you make this plea here today, you're going to tell us you are in fact guilty of domestic violence. People will dismiss the felony charge of child abuse, and that's how the matter is going to be resolved. There will be no trial of any kind. Is that your understanding, and is that your intention?
Yes, Your Honor. That is my understanding.
Has anyone tried to frighten you? I'm sorry, go ahead. Say that again if you would, please. I didn't mean to cut you off.
No, that was my understanding, my intention, Your Honor. So, yes.
Has anyone tried to frighten you or force you or intimidate you into doing this?
No.
Has anyone made any promises to you that have not been placed on the record here today?
No, Your Honor.
Are you currently on probation or parole for any other criminal convictions?
No, Your Honor.
The allegation indicates that this is an incident that occurred between January 1st, 2023 and March 23rd, 2025. Does that sound right to you?
Yes, Your Honor.
The allegation is that this incident took place in Ganges Township of Allegan County in the state of Michigan. Does that sound correct to you?
Yes, Your Honor.
The allegation is you made an assault or assault and battery upon Maxwell Akey, resident or former resident of your household. Is that true?
Yes, Your Honor.
Who is Maxwell Akey?
He is my son.
And how old is Maxwell Akey?
He is 9 today, Your Honor.
And what did you do that constituted the assault and or assault and battery?
Your Honor, may I ask my client questions to establish the factual basis if the court would so allow?
Well, sure.
So, Mr. Akey, you acknowledge that between January of 2023 and March of 2025, there were incidents where you lost control of your emotions. You had emotional outbursts and lost control of your anger. Yes. And on certain of those occasions, Mr. Akey, did you also engage in physical conduct like slamming doors and engaging in other sort of aggressive conduct? Yes, Mr. Townsend. And Mr. Akey, did you understand Maxwell was there, and you understand that your actions during this time period placed Max in fear of an immediate contact that was unconsented.
Yes, sir.
Okay. And again, was Max a member of your household during this time period?
Yes, sir.
Okay, Your Honor, again, I think that's a sufficient factual basis for the assault as charged in count 2 of the felony complaint, unless the court has any additional questions.
Was there physical contact in these exchanges?
No, Your Honor.
Now is a good time to just come forward with things, because we are, whether or not we put this matter into diversion, it's an important aspect that I feel as though that we have someone who's taking full responsibility for their actions.
Absolutely.
I understand that things happen, and that's why we utilize diversion to help people, provide them with counseling, anger management aspects and such, to prevent such things from happening again. But there's a little bit of a caveat with diversion, please. Well, let me explain though, just so we make sure that we're not just ships crossing, missing each other in the dark, so to speak, or in the fog.
Yes, sir.
Diversion requires accepting guilt and taking responsibility and really owning it. And then we can deal with it with the counseling and such. And then hopefully I have every reason to believe you would be fully successful if we did utilize diversion. Not saying I'm going to do that yet, but if we were to do that, the exchange on that would be, this would be removed from your public record. So, but if there's not owning the situation, it's hard to get to that point where we are able to work with it. Do you see where I'm going?
Oh, I am owning to this, and absolutely am looking forward, as my family is too, and into me working through this diversion program in rehabilitation and making sure that these things never occur again, and that I have a loving, working, functional, that Max has the best atmosphere at his home that we can provide, and that I absolutely this is the plea, this is what I would like and what my wife would like to see with me as well, and I absolutely feel horrible, absolutely horrible. I haven't been able to sleep at all, and this has just been, I can't tell you how awful an experience, and I'm so sorry for, I absolutely own up to any of that Max may have felt.
Okay, here before we go much further down the road here, and I get the idea that you have a sense of contrition and such, but owning actual actions and the idea, there's a little bit of a separation here. And the reason I'm pushing back on this, sir, is because I'm kind of looking at the affidavit for the warrant to begin with, and I don't know if you had a chance to review that with your attorney. And if you want, I'll let you do that, and we can come back to finish up with this if you haven't done that. But there's some rather specific allegations in there that, at least to my mind, are, something that I think it's worth it for us to invest in, saying, okay, here, this is what happened. It's wrong. I own it, and we're going to go into this diversion program, and and we move forward. But of all the times to own something, now is the time, because you have a path forward here. So,
And Your Honor,
I don't know, if you'd like a breakout room, I'd let you do that. I don't want you to discuss it in open court in front of me and such, because I certainly don't want to deprive you of, and I certainly don't want to put words in your mouth either. But the thing is, I'm really wanting to have this to be, if we utilize diversion, I want it to be effective.
yes, and Your Honor, let me step in here on behalf of my client. And we've had the opportunity to review the affidavit. We've had the opportunity to discuss both the alleged incidents in that affidavit and the discovery that we received from the prosecutor's office about those. Just so I'm clear with the court, I recommended, my client is not prepared to say that either of those incidents happened. And I personally feel like the defense has good arguments about those. I think what we're saying, Your Honor, is that notwithstanding what's alleged in the affidavit, that my client has engaged in a course of intentional conduct, both verbally and while not involving physical contact to the child, these loss of control episodes with the slamming of doors and the nature of the outbursts, my client knew put his son in reasonable apprehension of immediate contact. I will also say, Your Honor, that defense's understanding is that the misdemeanor plea here would be, for the assault, based on my conversations with the prosecutor's office even this morning, would be eligible for diversion. And so if there's any misapprehension, if there's any crossed wires here, I take full responsibility for that. But I wanted the court to have the benefit of that insight as we're going through.
No. I'm not saying he's not eligible for diversion. I'm just saying whether I'm willing to put him on diversion. That's my concern, because to me, putting someone on diversion, means that, we have fairly strong confidence that they're going to own the situation, and then by owning it, we're going to be able to work on it rather than just tiptoe around the shadows. Understand, I mean, it's absolutely eligible, but there's no promises in regard to my sentencing is on anything. Recommendations of the prosecutor are very much welcome and accepted, as are recommendations of defense counsel and even statements the defendants make on their plea. But once we go beyond that, I take that into consideration, and then I pronounce sentencing. So again, I am not trying to put words in anyone's mouth. I'm trying to make sure that we have the most successful possible diversion program. If you want a moment to talk about it, that's great. If you don't, we can just proceed, and I will inquire of Mr. Duffield and proceed from there.
Yes, maybe just have a brief moment with my client then, Your Honor.
All right. Give him a breakout room then. Or actually, we can just, if you just mute yourself, we won't hear you, so that's fine.
Honor, if you can hear me though, please advise. But I am going to mute the mic.
Yeah, we can hear you. So if you want to mute yourself, that'd be better. All right, let's go, Mr. Thompson. You and your client, I think you indicated you were ready, so let's go back on the record with that matter.
Thank you, Your Honor. Yes, my client does have some additional statements he would like to make to the court. I think my concern as his counsel is, if the court is not satisfied, I think my preference would be to take a break and to adjourn this to do some more work if we need to. And I know the court can't tell me in advance what its ruling is going to be without having heard from my client, but I want to make sure that I'm effectively representing his interests. And I think with what's at stake, I'm concerned based on the colloquy to this point.
You're concerned based on what?
I'm concerned based on the court's reaction thus far to on the acceptance of responsibility. And so my advice to my client is that we may want to consider adjourning this to do some more work. He has other things he would like to inform the court, but the stakes are high for him. I want to make sure that that he's being intentional and that everything is being done appropriately. So that's where we are. He's happy to make an additional statement to the court, though, that I think may assuage some of the court's concerns.
Yes, Your Honor.
Well, if he's willing, I'm not asking. I don't want to put words in anyone's mouth. If he wants to make an additional statement, that's fine, and we're able to proceed. We take care of these matters all the time. I mean,
Sure.
But I'm trying to ensure that we make these diversion programs as effective as possible. And that's why I don't allow it. I'll just let you know, counsel, I don't allow people into my diversion programs on a no contest plea because, well, they're not taking responsibility. So
Sure.
that's
why. Your Honor, I understand, Your Honor. I don't think that's at all what we have here. And I'm hoping that my client, who completely understands.
Well, let's go. Let's hear what he has to say.
Your Honor, I'm completely, absolutely 100% taking responsibility for this. I absolutely understand that I may have placed maximum reasonable apprehension in that may have threatened him. And I absolutely feel horrible for my actions. I absolutely want this diversion program more than anything. I really want this for my life and for this to go this way more than anything. I really am begging for mercy on this and pleading and praying with God every minute that I can go in this direction and have this so I can move on with my life and I can go on and enjoy my son's birthday party with him today, and we can move on in a positive direction and I can receive the help that I need in my family. We can move on.
Your Honor, may I clarify 2 points with my client? Mr. Akey, you mentioned that you may have, but you did engage in sort of intentional
I do
conduct.
understand that, Your Honor.
Let me finish my question. You did engage in intentional conduct towards your son that you knew was placing him in fear of immediate contact. And you understand, Mr. Akey, that was inappropriate.
Yes, Your Honor, Mr. Townsend.
Okay, I just want to make sure, because
I
you
do
said may
understand
have.
that. I'm so sorry. I do
Okay.
understand that. I absolutely 100% am taking full responsibility and begging for this diversion program, please.
And that happened, the things you're saying
These
happened.
things, yes, 100%. I'm taking responsibility. They happened. I'm not trying to say they did not in any way, shape, or form, Your Honor.
Okay. Thank you, Your Honor.
Mr.
Thank you for the patience.
Mr. Duffield, are you satisfied with the plea?
I am satisfied with the plea, Your Honor. Thank you.
And Mr. Townsend, I believe you already stated you were satisfied with the plea.
I am, Your Honor, and again, thanks to the court for its patience in allowing us to speak.
Any further recommendations, Mr. Duffield?
Just, I do think, especially based on the statements just made, that Mr. Akey would be a good candidate for the court's diversion program and would encourage the court to sentence him thusly. Thank you.
Thank you, Mr. Duffield.
Mr. Townsend?
I agree with the prosecutor's recommendation, Your Honor, and particularly in light of what Mr. Akey has said here today and his lack of criminal history. I do believe this is a blip on the radar for him. He knows the seriousness and the importance of what's gone on here, and I do strongly support this request for diversion. Thank you.
And Mr. Akey, anything further?
No, Your Honor.
Okay, that's fine.
I understand.
All right. We'll go ahead and place this into the diversion program for a period of 12 months or $625 oversight fee associated with it. Purpose of probation is to provide the defendant with counseling, anger management, and or batterers counseling to enable you to learn how to deal with anger impulses and flashpoints, to be able to engage with individuals with whom you have a domestic relationship in a constructive and civil manner. The no contact in this matter has been adjusted to non-assaultive contact, and that will be continued. Upon completion of the diversion program, the case will be dismissed from the public record. The $625, I'll give you the period of probation to take care of that, but whenever you'd like to is fine. And do you have the number for our probation department?
I don't believe we do, Your Honor, but we can certainly get that from the court.
It's 269. Make this stick.
Yes, sir, Your Honor.
Good luck to you. You can leave the court.
Thank you, sir.
You're welcome.
Thank you guys so much for another amazing night. Every night with you guys is great. Be safe, be well, sleep sweet, and much love.